Welcome to the latest Eversheds Sutherland Legal Insights podcast.
I did actually see a non-compete one time that included, as part of the territorial restriction, the entire Milky Way. I think that one might have been a little tough to enforce, but...
Welcome back, everyone. We are excited to have you join us for Conversations Across the Pond, where we will compare and discuss employment law in the US and Ireland. My name is Emma Quinn, and I'm an employment lawyer at Eversheds Sutherland, based in our Dublin office in Ireland. And I'm joined today by my colleague Bonnie Burke, who is also an Eversheds Sutherland employment lawyer based in our Atlanta office in Georgia. Bonnie, considering you have been the resident jokester in these podcasts, I was really trying to think of a Christmas-related employment law pun, but I only got as far as unfair dismissal. I really tried. I tried my best.
Oh, that one's good. Emma, you're almost as funny as me. Say it ain't snow.
You can tell I am very excited for the holidays. But anyway, on today's episode, Bonnie and I are going to be talking about all things contractual protections, from your confidentiality, your IEP clauses, all the way to your restrictive covenants. So, Bonnie, it would be quite standard to have IEP and confidentiality provisions in Irish employment contracts. And I know from our last episode that it's mostly your senior execs and your upper level management who have employment contracts in the US. How are IEP and confidentiality generally dealt with in a US employment context?
You're right. So for those senior executives and upper level management, often the IP and confidential information protections are included in the employment agreement, or maybe more often in a separate agreement that might also include some restrictive covenants, depending on where these people are located. In some states, restrictive covenants such as non-competes can only be agreed between the employer and the employee if the employee has also been given access to the employer's confidential information, which usually includes that IP. So it makes sense to include those protections in the same agreement as the restrictive covenants. But because the laws change from state to state and time to time, it often makes sense to have those protections in a separate agreement that can be modified from state to state and time to time without having to amend the employment agreement. Those separate agreements protect the employer's confidential information, their IP. It may include those restricted covenants, like I said, and they're often given to other employees who may not have employment agreements, maybe only an offer letter, but who will come in contact or create that confidential information and IP for the employer. We usually also recommend to have policies in the employee handbook that protect confidential information, both during the employment and after, in case you have some employees who don't receive the agreements but may occasionally come in contact with company confidential information. What about in Ireland?
Well, in Ireland, it's always really important to have a detailed confidentiality clause in your contract. And sometimes I see a clause that applies for the duration of employment, but for only 1 year post-employment, which is just madness in my opinion. And a confidentiality clause should always be perpetual in nature.
Yeah, same in the US.
Yeah, and then I suppose under Irish employment law, IP created by employees is owned by the employer, provided that it was created in the course of the employee's employment with that employer. And then generally under Irish employment law, IP created by an employee other than in the course of their employment is owned by the employee. So I suppose this presents real challenges for employers. Whether or not IP was created in the course of employment really often is the subject of legal argument in the courts. So I suppose at a minimum, it's always good if the contract of employment specifies that the employee acknowledges and agrees that all IP rights in any matter made or discovered by the employee during the course of employment, whether or not during office hours, affecting or relating in any way to the business of the employer, have to be disclosed to the employer and belong to the employer.
That protection is also generally a good idea in the US. The IP laws can vary a little bit from state to state, but generally, IP created by employees in the course and scope of their employment and with the employer's equipment will belong to the employer. That's not true for independent contractors, so always good to spell that out in the independent contractor agreement. For employees, there are a few states that require there to be a written agreement with employees about the IP ownership, and those agreements must specify that the inventions created on the employee's own time without the employer's equipment, supply, facilities, or trade secret information belong to the employee unless the invention results from work the employee was doing for the employer or can be shown to stem from the employer's research and development.
I mean, the fun really starts post termination, doesn't it, Bonnie? Would non-solicitation clauses be a big thing in the States?
Yeah, they are. Employers do want to protect their current clients and the clients that they are actively pursuing for business, as well as their current employees. They invest in their people and they want to hang on to that talent. So we do see this quite a bit. The restrictions on drafting are often the same or similar to those of non compete provisions, but they can be a little looser and a little more forgiving. They still need to be limited in time, scope, and geography, usually with limits to who the employee had actual knowledge of or contact with. It varies a little bit from state to state. The typical duration is about 6 to 12 months. Would you normally see a non solicitation clause in Ireland, Emma?
Yeah, absolutely. It would be very standard for Irish contracts to provide that an employee can solicit customers, clients, employees for a period of 6 to 12 months post termination. We would also see non-compete provisions in Irish employment contracts as well. Would they be common in the States, Bonnie?
Oh, yeah. They were actually one of the hottest of hot topics this year. We have had a few states that have banned them outright. So, California, which also carries criminal penalties if you include it in an employment agreement, Oklahoma, North Dakota, Minnesota. There are several other states that have created restrictions, usually like salary thresholds or requirements that the employees only, or that the agreements are only going to apply to executives or upper level management. So, there is a lot of restriction on those agreements. But last year, we saw the Federal Trade Commission introduce a rule that proposed to ban all post termination non compete provisions and provisions in agreements that acted as a de facto non compete. So, possibly an overly broad non solicitation or a requirement that employees repay certain costs to their employer, like training costs, because they acted as a block to the employee leaving the employer and working for somewhere else. The FTC's final rule passed in April of 2024, but then it was halted by a nationwide injunction in August. The FTC has filed an appeal, but given the change in control in the White House, I don't think we're going to see the appeal go any further, and it'll likely be withdrawn. I think some states that wanted to pass some legislation or restrict or prohibit non compete sat still for a moment to see what would happen at the federal level. And now that the federal rule is not going to go forward, we're likely to see that activity resume at the state level. But the lesson in all of this and what comes out of the state laws, I think, is that non compete should really be given only to the upper level management and executives and not necessarily to every employee of the employer. The duration of post termination non compete provisions has also gotten shorter over time. Now we tend to see the agreements that are like 6 months or a year, whereas 10 to 15 years ago, we frequently saw those restrictive covenants with 2-year provisions.
That's crazy that there's potentially criminal sanctions for employers who use non-competes in certain states.
Oh, no, only
Oh,
California.
only California, sorry.
Yeah.
We don't have that in Ireland anyway. I suppose in Ireland, I've always found non-competes really interesting because all Irish citizens have a constitutional right to earn a livelihood. So if a contractual restriction impinges upon that right and prevents an employee from earning a livelihood, there's a chance that if challenged, the courts will be unwilling to uphold the restriction in question. So I suppose prohibiting an employer from working for a competitor at all could theoretically prevent an employee from earning a livelihood. And I suppose a lot really depends on the nature of the role and to the extent on which an employee can actually earn a livelihood without being in direct competition with their former employer. And really to ensure that a non-compete provision isn't challenged, the contract might specify that the non-compete is reduced by any period of garden leave or, like the US, it might be limited in geographical scope. So, it might say that you can't compete with a competitor within 20 miles of the office address, or within the city of Dublin, or within Ireland. And kind of in our experience, a worldwide non-compete is definitely going to be unenforceable. But I suppose similarly to the US, kind of our non-competes would be anywhere between 6 and 12 months, and anywhere above 12 months, we'd be raising that as an issue that they're probably going to be unenforceable.
That's pretty similar to the US, but the way it may have played out in reality in some locations may need to be reined in a bit. I think that we've seen with the FTC's rule and some state laws, the attempt to kind of restrict how often these non-competes are being given out to people and just how far-reaching they can be. I did actually see a non-compete one time that included, as part of the territorial restriction, the entire Milky Way. I think that one might have been a little tough to enforce. But so what about non-disparagement clauses? I think in the US, we've seen some back and forth lately on this one as well. Under the Biden administration, we saw the NLRB and the EEOC express their disapproval of non-disparagements, particularly where they were pretty broadly drafted. We've already heard that the Trump administration may take a different perspective on this. But again, I think a clause that makes it clear what the employee or the employer can and cannot say, how they can say it, whether it's social media or however else, and against whom, is likely a better protection than something that's too broad and a bit vague. We've seen just a couple of states adjust their laws to limit these clauses. Colorado is one of them, where they prefer a mutual non-disparagement, if any at all. What about in Ireland?
I suppose we wouldn't have any kind of mutual non-disparagement clauses in our employment contracts, but we would often see non-disparagement clauses in the context of a settlement agreement. So I suppose in the case of a normal employee who resigns without any issues, the employment contract won't cover any issues of an employee giving out about their manager or the business in general. But Bonnie, I think that's all that we have time for today. And I can't believe the next time that we're going to be chatting, it'll be 2025. We're gonna have
believe it.
I know we're gonna have to do a 2024 kind of roundup episode at some stage. But no,
I think that's a great idea. Yeah. Well, thank you for listening. Thank you for participating, Emma. It was great to see you again. To all of our listeners, thank you for listening. And don't forget to subscribe to our podcast and share it far and wide. You can find our contact information in the show notes. Tune in next time for more employment law conversations across the pond.
This podcast is presented by Eversheds Sutherland and is for informational purposes only. The content of this podcast is not intended to constitute legal advice or a recommended course of action in any given situation. This podcast is not intended to be and should not be relied upon by the recipient in making decisions of a legal nature with respect to the issues discussed herein. The listener is encouraged to consult independent legal counsel before making any decision or taking any action concerning the matters discussed in the podcast. This podcast does not create an attorney-client relationship between Eversheds Sutherland and the listener.